Last month, the Supreme Court of Canada ruled that the Federal Impact Assessment Act, or Bill C-69, was largely unconstitutional. This was a win for the province of Alberta and a win for many energy and climate-focused businesses looking to invest in the province. But what does this mean for the future of energy in Alberta, and where do we go from here? Hey there, you're listening to the Brief, an Alberta Better podcast series. I'm Brittany Brander, and in this series, my co-host, Scott Crockett, and I explore Alberta's big challenges, celebrate those stories of growth, innovation, and prosperity, and discover bold ideas to make life better for Albertans. In this episode, we are joined by Sean Sutherland, partner in litigation at Osler, for a deeper dive into the significance of the Supreme Court's ruling, how this decision impacts provinces across Canada, and the immediate implications for public policy. We also learn a little bit more about the Impact Assessment Act itself, how it was received across Canada, and what Sean thinks the next iteration might look like. If you found this episode interesting or insightful, let us know by heading over to Apple Podcasts or Spotify and give us a quick review and a rating. Now, on to the show.
Welcome to the podcast today, Sean. And if you would, just begin by introducing yourself to our listeners for anyone who hasn't had the chance to meet you yet.
Sure. Well, thanks very much for having me today, Scott. I'm a litigation partner in the National Litigation Group at Osler, Hoskin and Harcourt. I've been practicing for about 10 years, and my practice is focused on major resource projects, primarily how we can help get resources to market and avoid court challenges. So I spend a lot of my time fighting with governments, fighting alongside governments, and working with Indigenous communities, environmental groups, etc., to see if we can find a way forward. Of course, as a lawyer, I have to start with a general disclaimer.
Perfect. You wouldn't be a lawyer if you didn't.
Exactly. All the views that I express today are my own. They don't represent my firm. They are not legal advice, and they are certainly not necessarily the views of all my clients.
Great. Well, let's get into those views. Well, we certainly work in parallel worlds because I find myself working with a lot of those groups from time to time as well. And Sean, recently you were working with the Business Council of Alberta, where you were representing us as interveners on this recent Supreme Court reference case. You know, I always like to say these podcasts are great when we do them the way that Quentin Tarantino does a movie. You know, you sort of jump to the end, give a little preview, and then circle back around to the beginning. So help us jump to the end. Give us the bottom line up front. What's the 30-second version of the story?
So without a doubt, the Supreme Court of Canada's decision in the reference case is among the most important environmental decisions in the past 30 years in this country. So the headline is, the Supreme Court of Canada has found that one of the federal Liberal government's signature legislative initiatives to assess and make decisions regarding major resource projects is not constitutional. They went far beyond the scope of federal regulatory powers over the environment, and in doing so, upset the balance inherent in our Constitution between the provinces and the feds. So it's time for Parliament to go back to the drawing board and figure out a different approach, which they're doing right now.
So very significant. And just for the record, this is in reference to, Bill C-69 or the Impact Assessment Act. Folks around here call it by a variety of different names. So if that's the end, this signature significant piece of environmental legislation has been found by the Supreme Court to be unconstitutional. Let's back up a little bit though, Sean. Talk to us about when and why was the Impact Assessment Act created?
So the Impact Assessment Act is the most recent iteration of what is 30 plus years of environmental assessment at the federal level in Canada. Of course, we also have environmental assessment provincially, but it seems to be the most controversial when it's the feds looking to regulate. And the reason for that is most major resource projects in Canada are going to be located wholly within a province. And back in 1867, when our founders of this country formed the Constitution, they assigned powers to the federal government and they assigned powers to the provincial governments. Intra-provincial projects wholly within a province, or what would be known under legal terminology as works and undertakings, were for the provinces. Whereas interprovincial, those projects across borders, like in 1867, the railroad, or more recently, pipelines like Trans Mountain, that was
transmission lines maybe as well.
Precisely. That was for the federal government. And so because environmental assessment touches on all those projects, there's different rules of the game depending on what type of project you're dealing with. So in the early 90s, then the federal government sought to regulate and assess these areas. There was a decision called Old Man River that found that the federal government did have authority, but the exact scope was left open. So over the succeeding decades, there were various iterations of environmental assessment legislation. And of course, there was a tension between the provinces and the feds and different governments. So when the federal Liberals were elected in 2015, they campaigned on reforming federal environmental assessment. There was a view that the Harper government had deregulated and sped up timelines in a way that reduced the level of scrutiny that major projects went federally. So the result of that was that the federal Liberals went through a 3-year process to consider a new impact assessment regime. And what they came up with was the Impact Assessment Act.
So I think it would be fair to say that act was not universally popular, particularly with folks interested in doing major projects in Canada. So, give us a sense, put yourself in their shoes. Why did or do many jurisdictions and other actors as well, why did they have issues with this act?
So there were many. And many of those groups, the provinces, business organizations, industry, were involved in the legislative process and made submissions. And this was an extraordinary piece of legislation because the Senate actually proposed over 190 amendments to it, largely in response to some of those concerns that were raised by the provinces and business groups. So there were a few concerns raised. One was timing. So when you're making an investment decision, you want to know roughly how long is it going to take and what's the process going to look like. And the proposed act, and the act, in fact, in the form that it took when it was enacted, left both of those things uncertain. So for an investor, particularly investors that are going to spend billions of dollars, sometimes $1 billion before the project is even built.
Yeah,
this is a lot of uncertainty.
A big pipeline for sure. Yeah.
So that was one of the concerns. The other one was over the final decision. So the act puts a lot of power within political bodies who make policy decisions that can shift from government to government. So again, when you're looking at proposing a major project, investing in this country, that final decision needs to be something that you can predict with some certainty.
Right. So just to put kind of a fine point on that, I think one of the areas of political concern was that there was, effectively a ministerial veto associated with this, strong ministerial powers. And I think many, certainly project proponents or business groups were concerned that you could end up, a long way down a project process, as you said, maybe $1 billion or more invested. And frankly, it could be up to the decision of a single political person, political entity. And those things change from time to time.
Precisely.
Now, tell us, how did we end up with a reference case in the Supreme Court? Tell us a little bit about that.
So the reference procedure is an extraordinary one in Canada. Provinces and the federal government have a statutory ability to refer a case directly to their Court of Appeal or the federal level, the Supreme Court. And it's usually reserved for only the cases of the highest public interest. So think back in the early 2000s. The federal Liberal government referred what was then very novel same-sex marriage legislation to the Supreme Court. Similarly, when the province of British Columbia was looking to regulate the Trans Mountain Pipeline project just a few years ago, they referred proposed legislation to their Court of Appeal.
Their sort of highest provincial court.
Exactly. Yeah. And so the purpose of it is, how can we get an answer on this issue of high public interest as soon as we can from the highest level of court possible? And so that's what happened here, is the province of Alberta, shortly after the Impact Assessment Act came into force, referred it to the Alberta Court of Appeal, who in a 4-1 decision said it was unconstitutional. Now in a reference case, you get to go to the Supreme Court and you get to go there quick. So the feds immediately appealed it, and that's how you ended up with the matter before the Supreme Court.
And while this sort of was spurred by Alberta, most of the other provinces also felt in similar ways, as well as many sort of business groups. Maybe you could tell us, in your view, why did most of the provinces oppose this legislation, and why did business groups like the Business Council intervene?
Let's start with the provinces.
Sure.
This was an extraordinary case because every single province sought to intervene at the Supreme Court of Canada in opposition to the legislation.
So all 10 provinces at the end of the day did, hey?
Some of them didn't end up making argument, but they all sought leave to appear. And that's an extraordinary thing in this country. They all had different positions, of course, but it goes back to that balance we talked about. In 1867, the founders of Canada, this country was based on a balance between federal and provincial decision-making. And the provinces saw this as a federal attempt to override that and impose their own decision-making based on federal policies and priorities over what provincial resources can move ahead to project level and lead to economic benefits to provinces. And we're, of course, a resource-heavy country. We rely on resources across Canada, whether it be the Atlantic provinces, British Columbia, the Prairies, Alberta, Ontario, everywhere in this country, we rely on resources. So that was why the provinces were there. For business groups like the BCA, it was more practical. The Act made it a lot more difficult to build projects in Canada. Now, the arguments were, of course, framed under the Constitution. And one of the things that's interesting about constitutional law is that it's not just legal theoretical arguments. The practical effects are relevant. So groups like the Business Council of Alberta were there to make that point, that the practical effect of the legislation was it made it a lot more difficult to build projects in Canada, in a lot of ways put this practical veto on projects even being proposed.
I think that's really well put. And while we made some, quite specific legal arguments, or in fact, you made some quite specific legal arguments, I think you painted a good picture of sort of what the broader concern area was, which is this act is a big part of why many people were concerned that Canada was becoming a place that was very, very difficult, in some cases borderline impossible, to get major projects built in. And this is not the only piece of legislation that sort of impacted that, but certainly it's been one of the biggest changes over the last number of years and kind of one of the most painful. So let's dive into the decision a little bit. You and I spoke, I think, within 15 minutes or so of this decision becoming public. And at that stage, you'd had just enough time to skim it, which was great. But I think it was a couple hundred pages or more that you knew you were going to have to dig into in the days that followed. Give us the top line, a little detail. So what was the decision and why did the court find that way?
So the decision was, by 5-2 majority, that the act was unconstitutional. And the Supreme Court had a couple concerns that really led it to get to that conclusion. The first of them was that the court was concerned by the fact that the act regulated projects in their entirety, rather than just considering more narrow aspects of federal jurisdiction. So to back up a little bit, think of it as two different types of jurisdiction: an effects-based jurisdiction and a project-based jurisdiction.
Effect-based and a project-based. Okay, I'm with you.
So if one level of government has jurisdiction over the project, that's that power I talked about earlier, that works and undertakings, provincial projects or federal projects. That's a broader assessment. So the federal government over the Trans Mountain expansion, that's a broad project level jurisdiction. They're assessing and regulating the life cycle of the project. But let's now think about an oil sands project or a critical minerals mine.
Right.
That's within a
petrochemical
province.
Facility.
You've got it, exactly. That's the type of thing that the province is the one with that project level jurisdiction. Now in Canada, the environment's not listed in the Constitution. So we've got to figure out, what do you do when an effect of a project is within another level of government's authority? So go back to that petrochemicals facility or the oil sands project,
right,
or the mine.
Very, very relevant examples where we sit here in Alberta at the moment.
Exactly. There's probably a fishery nearby. The federal government has power over fisheries. So the effects-based jurisdiction is the effect of the project on the fishery. But that's a lot more narrow than looking at that project as a whole, as a life cycle regulator. So what the Supreme Court said about the act was the problem is it treated everything the same and allowed the feds to look at the project that they only had that more narrow effects-based, for example, fisheries jurisdiction over, and start considering whether things like the federal view on vague terms like sustainability were enough to allow the project to go ahead, or if it was something that would lead the feds to stop the project. So that was the first concern. The second was that the act had a defined phrase, effects within federal jurisdiction. And their argument was, well, we're only focused on effects within federal jurisdiction. Look at what the act says. The problem is, when you actually looked at what they listed as effects within federal jurisdiction, it was way too broad. So I talked to you about sustainability. Sustainability is not a power under the Constitution, nor does anybody know precisely what it means. It's a very subjective term.
Sure.
So that was one issue.
Important, but subjective. And, you and I would probably define it differently if we had to write it down right now.
That's right. And there were other things as well that went beyond those federal environmental effects. One that got a lot of attention when the act was proposed was the intersection of sex and gender. Well, that's not an environmental issue. That's a social policy. So the act went just far beyond what environmental assessment typically considered. And then at the end of the day, the big problem was it let the federal government make a decision based on those factors. So the federal government could look at the project and, again, going to the words of the act, determine what is in the public interest based on any factor it considered relevant. And that was just simply too broad.
So, again, to sort of distill that, what you're saying is that based on the act as it was written, the federal government could effectively say this project can't go ahead, and the reasons that it might decide that it was not in the public interest could be outside of what was the federal government's jurisdiction. For example, it could be based on sustainability factors, broadly defined or loosely defined, or even on sex and gender factors or other social factors.
That's right.
So let's get specific. What does this decision mean and what does it not?
So what the decision means is that the federal parliament has to go back to the drawing board, and they've got to come up with a version of the act that's more narrow, because we're always going to have federal environmental assessment in Canada. It's been around for decades. The question is just how broad is it going to be, and how's it going to work with the parallel provincial processes? So that's what the federal parliament is working on right now. And I'm sure, as many of the listeners will recall, within minutes of the decision being issued, the federal minister of natural resources and the federal minister of environment and climate change gave a press conference where they said they would work on amendments to the act.
Right. And I heard reports of working groups within the federal government, brought together and spun up that very day.
Absolutely. So they're working on that right now. What the decision does not mean is it does not mean that the federal government has no role in respect of provincial projects. They do. It's just more limited to assessing the effects on those things like fisheries. It's not about the holistic public interest federal priorities views on things.
So one of the things that I thought was kind of interesting, because, I haven't been involved in a lot of constitutional challenges previously, is the question of, does Canada today have an Impact Assessment Act in place?
It does. So what's interesting about reference cases is, notwithstanding they're the cases of the highest public interest, they're not legally binding. They're an advisory opinion. Now, interestingly enough, lower courts need to follow what the Supreme Court says. So there's, of course, a practical effect of a reference opinion. And we do live in a constitutional democracy where the legislature typically listens to what the court tells it is lawful. So as a practical matter, it is a practically enforceable decision. And the Ontario government, shortly after the decision came out, and actually to back up a bit, the Ontario government in its capacity as a project proponent in many ways, because it's proposing a Highway 413, that it very much wants to get built as quickly as possible.
Designed to open up some critical minerals and other economic opportunities.
And under the Impact Assessment Act right now. So the Ontario government has launched a formal challenge to make that Supreme Court decision enforceable, give it some teeth. So they're in the federal court right now with that proceeding, and that would make that advisory opinion a binding declaration that would result in the act being declared unconstitutional.
So, speaking in my words, I would say that it's just an opinion by the Supreme Court. That's what's been put out. We still have an Impact Assessment Act today. But because of the structure of our country, common reasons why it'll likely be the legislature will pay a lot of attention to it, for one thing, our legislators will, and why it could become practically very interesting very quickly. So talk to us about the immediate implications of the decision. And I'll make it a double-barreled question, because a specific question that I got asked by a few folks was, does this increase in uncertainty in the near term?
So a couple weeks ago, the Minister of Environment and Climate Change Canada issued some interim measures that are going to be followed in the near term. There's a difference between projects that are currently under the Act and projects that could become subject to the Act. So the minister is proposing that the Impact Assessment Agency of Canada continue to look at projects that are under the Act. So if you were already scoped in the Act, and there's 20 or so projects that were, the Impact Assessment Agency is going to take a look and decide whether they should continue to be under the Act based on what the Supreme Court said. However, the minister has said that no longer will they be issuing discretionary designation orders to scope projects into the Act. So no new projects being scoped in under that discretionary power the minister had to do so. So there's a differential treatment in the short term in terms of projects. So we'll see whether or not courts uphold that process or not, because of course the Supreme Court has just said the whole thing is unconstitutional in terms of the assessment of those designated projects. So to be determined, and some legal uncertainty there. But as far as the long term, whether there's going to be more uncertainty as a result of the decision, that depends a lot on what the federal government does here. If the federal parliament looks at this and comes up with substantial amendments, a very different version of the Act that is directly responsive to what the Supreme Court had to say, then there'll be more certainty, because we'll know we have an Act that withstands legal scrutiny. But if the federal parliament goes back and in their attempt to amend the legislation does so as narrowly as possible, and in ways that the provinces or industry don't think go far enough, we're just going to be back in front of the courts arguing the case again.
So one of the arguments that's been made in the last couple of weeks, and I'll get you to give your own opinion on this, is whether the changes that need to be made to the Act are major and likely to take a long time, or are relatively simple and just a few tweaks. Where would you put it on that spectrum?
I think they're quite significant. I know that depending on where one falls along the political spectrum, the perspective can be different on these things, but I do think they're significant, and you don't need to look much further than the words the Supreme Court used to determine that. They said far beyond the federal legislative jurisdiction, not barely beyond. So as a result, this is really going to have to be a rethink by the federal government in terms of what these assessments look like. And that is going to take a while to do properly. And just going back to what I said earlier, the first version of this act took 3 years, and there were 190 proposed amendments. So it's to be determined what this is going to look like. But if these amendments are narrow in scope, there's a very real risk that everybody's going to just be back in court. And that's not good for business in this country.
Right. Did the Supreme Court offer any guidance to the federal government on what they should do and how they could bring it within their own jurisdiction?
There is some guidance, absolutely, and we've got a theory in constitutional law called dialogue theory, which is that when the court speaks and the legislature responds, it's a dialogue between the two to get to the right result that is within our legal framework. And that's sort of what's happening right now, is the Supreme Court gives some guidance and Parliament has to look to respond. Here, there is some guidance. In particular, I mentioned that definition of effects within federal jurisdiction and the need to focus on what are the actual effects within federal jurisdiction, not what are the federal government's current policy priorities, but with reference to those listed powers going back to 1867 that were assigned to Parliament. What are those effects? So there's some guidance there as to really anchor federal powers with what's actually written in the Constitution. And sustainability is not there, as an example. So that is some guidance there. The other piece of it as well is the difference between the projects that are largely within federal jurisdiction, that assessment of a project, versus those primarily within provincial jurisdiction, the assessment of the effects. So if Parliament can distinguish between those two, that's going to be a big step in that dialogue with the Supreme Court.
So some people, including Alberta's provincial government, have read into this decision and thought about what it might mean for other pieces of either known or at least likely legislation that we may see coming. And particularly, I'm thinking about things like the clean electricity regulations that, just to be clear, we've been on the record, we think in their current draft don't really work for Alberta or don't work at all for Alberta, or a potential oil and gas emissions cap. The provincial government and others have said that they feel these things would be on much shakier ground now as a result of this decision. What's your opinion on that?
I agree. The decision certainly does not strengthen the federal government's position on those proposed pieces of legislation. And in particular, I'll direct all our listeners to the fact that the Supreme Court specifically referred to concerns over an overbroad federal approach to greenhouse gas emissions under the Impact Assessment Act, and was very clear that the decision a few years ago on greenhouse gas pricing that the Supreme Court had, where they upheld the federal legislation, was narrow. So the result of that is the federal government needs to look at those proposed pieces of legislation, look at this decision and consider, does what the Supreme Court had to say about greenhouse gases and emissions limit what they can do as a matter of constitutional law? So just to give you one example, is the Supreme Court, in its decision on the impact assessment reference, said that that definition of effects within federal jurisdiction, to the extent it allowed the federal government to say no to provincial projects simply because of an emissions-based concern, was too far. So when we're looking at how the federal government is deciding which projects can go ahead, when we're thinking of net zero and how to get there, that's got to be something that the federal parliament is very careful about, because the court's been clear that that is not something that is within the federal jurisdiction.
So it's not enough to say, we're going to say no to this project because it's going to increase emissions too much in the country. And that doesn't necessarily take anything away from our sort of national goals and ambitions around net zero. And as you know well, the vast majority of the companies that we work with are quite committed to that ambition also. But I think that's important to understand, because previously there had been a view that the federal government was so narrowly focused on the country's emissions and domestic emissions that could be used as a single decision point to axe a project. So you're saying that's out now?
Well, the Supreme Court was very critical, and the Supreme Court actually specifically referenced the fact that the minister had sent letters to some project proponents and advised them largely based on greenhouse gas emissions, if not exclusively based on greenhouse gas emissions, that he, on a preliminary basis, did not consider those projects to be in the public interest. So that the court actually went out of its way to specifically reference those things should give the federal parliament serious pause when they look at legislation that's going to be based on picking and choosing what projects get to proceed and what those are going to look like based on emissions alone.
So as we begin to get towards the end here, Sean, I'm going to ask you to do what, in my experience, all my lawyer friends hate doing, which is using a crystal ball and telling me what you foresee happening in this sort of the broad policy area, both with the specific act, but sort of, federal environmental assessment generally over the next, say, 12 to 24 months.
Well, it really depends on what Parliament does. Is Parliament going to go back to the drawing board and come up with something new and different that responds to the Supreme Court's concerns? Or is Parliament going to try and do the bare minimum to aggressively assert federal jurisdiction over this area? Which is very possible because it is a very important area in terms of federal policy. So either of those is possible. If the federal government does make broad amendments, we might have some real legal certainty in the area. And we might find ourselves in a position where proponents, provincial governments can actually look at the process and know what it's going to look like, how long it's going to take, and whether it's likely or not a project will be approved under it. But if Parliament goes back and makes the most narrow amendments that they think are reasonable here, then we're just going to be back before the courts. And of course, these challenges take years. So we're back to years of uncertainty in a time period where critical minerals, oil sands, metallurgical coal, all these things are in high demand around the world still. And so we have a real opportunity in Canada with all our resources to be a global leader in many of these areas. But if the law is not certain, if this is not seen as a stable regulatory regime, then investors will look elsewhere. And we don't want to have that happen, and we don't want to have to argue these things. As fun as it is for the lawyers, we'd much rather just help our clients get projects approved.
Well, you said a couple of things that I think are really important to underline there. I agree with you. I think Canada can play an enormous and important role in the world in the energy evolution and the energy transition that's going on in areas like exporting more of the world's cleanest natural gas, LNG, critical minerals, even or oil that can provide certainty, affordability, and a clean product to the world. So I think that that's really important. But you also talked about sort of certainty, and maybe my word would also be predictability. You know, the ability to look at the way that we assess and approve projects in this country and have a good sense in advance of what the likely outcome might be for a project.
Absolutely.
So, Sean, any last thoughts for us? You know, I'd say maybe in two respects. If you were to offer a little bit of advice first to the federal government on, you know, in your view, what you'd like to see them do in the next 12 to 24 months. I think you started answering that. And also for, you know, companies who are considering major projects, both within single province or that cross provinces, what would you advise them to be thinking about?
Well, I think in terms of the federal government, I'd like to see some acknowledgement of the fact that for a lot of projects, the province has got to be the primary regulator and decision maker, and looking at ways of cooperation. And the Supreme Court specifically mentioned that. They referred to cooperative federalism, cooperating together. We can't do it alone with one level of government in terms of the environment and major resource projects. Both need to be involved, both have a role. But that requires both levels respect the other, whether it's the province respecting the feds on things like Trans Mountain, or the feds respecting the provinces on things like critical minerals. So that's what I'd like to see in the next iteration of the federal act.
And then on the business side of this, you know, within this listener group are lots of chief executives of companies that propose major projects. What should they be thinking about?
I think they should be thinking about serious submissions and advocacy on the certainty needed, because the business community has a big role in legislative development, in educating legislators on what the practical effects are. We talked about that being why the Business Council of Alberta and many other groups were before the Supreme Court making argument on the issue. But it's really important that this act account for the practical effects of impact assessment on businesses, considerations of timing, considerations of scope, considerations of decision making, all around that certainty and that predictability that's required for a stable investment environment.
Well, Sean, you know, I want to say that I think that while I've enjoyed this podcast as well, I think this decision is frankly a net positive both for the country and for business certainty and for the major projects that we need for our country and for the world. So I want to thank you for your work on this and with the Business Council. It's been great working with you and fun doing this podcast.
Thanks for having me. Always a pleasure.
Well, thank you for joining us for this episode of The Brief, an Alberta Better podcast series. This podcast is a production of the Business Council of Alberta, and you can learn more about us at businesscouncilab.com. And we'd love to connect with you on social media, so give us a follow at BizCouncilAB on Twitter, LinkedIn, TikTok, and YouTube. And finally, don't forget to subscribe and rate the show and give us a quick review. Your support helps us to keep making more episodes. Alberta Better is available on Apple Podcasts, Spotify, or wherever else you get your podcasts. New episodes drop every other Tuesday. Thanks for listening, and we'll see you next time.